Hey everyone, this is the matter of Williams versus Harris. Mr. Williams, you are suing the Harrises for medical bills, pain, and suffering for injuries you suffered when a garage door at their house came down and crashed on your head and hurt your neck. You are suing for $300,000 for your medical bills and $125,000 for pain and suffering for a total of $425,000. Is that correct?
Yes, Your Honor.
And Mr. and Mrs. Harris, you all believe that this is his fault.
Yes, Your Honor.
And his injuries, his bills, they're all for him to handle.
Yes, Your Honor.
Exactly.
Okay, well, let's get into the legal sauce. Now, Mr. Harris.
Welcome to the courtroom where lifelong friendships collide with six-figure lawsuits. Today's case isn't just about a faulty garage door. It's about betrayal, blurred lines between loyalty and legal liability, and a neck brace that costs more than most people's cars. Mr. Williams is suing for nearly $500,000, claiming his best friend's broken garage door turned into a linebacker and tackled him to the floor. But here's the kicker. The friend says it's all on him, and he's got the lease to prove it. This isn't just personal injury court. This is personal pain, personal history, and potentially personal ruin. So buckle in. We've got clashing testimonies, receipts via text, and a judgment that'll leave you asking, can you really sue your best man after the wedding? Let's find out.
Your wedding.
Yes, sir.
That's pretty special.
Yes, it is. Now, we played football together, and, on a football team, he was better to me. I'm not gonna lie. I looked up to him.
Some of my best friends in my life I've made on the football field from 5th, 6th, 7th grade.
Yes, sir.
So I understand that friendship. So you all played football together, you grew up together. You're friends up until this incident.
Yes. And
What led you to be at their house this day?
basically, I was married for 10 years, Judge.
Yes, sir.
And
I was married for 21.
so you know how hard it can be, just being married in general.
Well, marriage is work, but rewarding work.
Yes, sir. Yes, sir. So I've been divorced now.
This is where the case hits differently, because this isn't some cold landlord-tenant dispute. This is a story rooted in childhood loyalty, weddings, football fields, and brotherhood. Mr. Harris wasn't just a friend, he was the best man at the wedding. And now, he's the defendant. When Mr. Williams says he still has love for Mr. Harris, you can feel that emotional gut punch. But here's the real question. Does love matter in a courtroom where only legal obligations count? The judge is navigating a storm of sentiment and statute, and it's about to get messier.
I talked to my wife, we agreed to let him in, and sure enough, it comes back to backfire in my face.
No good deed goes unpunished.
No
huh?
good deed goes unpunished.
So you do see that, though. Your man is trying to help you out.
Yes, sir. I wish I wasn't here today, Judge.
So tell me what happened. I mean, you're in a neck brace. You look like you are in a lot of pain.
I'm extremely
What happened that
That line right there, no good deed goes unpunished, might as well be the theme of this entire case. Mr. Harris opened his home, gave the man a place to stay after a divorce, and what's the reward? A lawsuit for nearly $500,000. It's a harsh reminder that courtroom logic doesn't care about intentions. Goodwill doesn't exempt you from liability. And when friendship meets faulty hardware, someone's going to pay. Question for you all. Have you ever helped someone and paid the price for it later?
And I was heading for the touchdown. But what happened was I got stopped by a linebacker. That was the garage door. It slammed down on top of my back. I mean, I've been hit by linebackers, 250 pounds, but it was nothing like this pain that I experienced, Judge. It basically pinned me to the ground and the door.
So this door crashed on top of your neck?
Yes, sir.
Okay.
It crashed from my upper back. I have a disc herniation from C4 to C6.
Now, y'all, this is your place, right? Your door. You own that door, right?
Okay, let's talk visuals. Mr. Williams paints a picture straight out of an NFL blooper reel. He's the running back going for a game-winning touchdown, and bam, the garage door becomes the defensive lineman from hell. It's almost comical, until you remember he's in a neck brace and facing a disc herniation from C4 to C6. Sometimes our instincts take over and we run on muscle memory. But this time, survival mode ended in surgery, not glory. Still, you gotta admit, linebacker garage door might be the most bizarre tackle story ever told in court.
Yeah, I forgot the code.
So running out of the garage was survival mode?
Correct, I had to get out of
Couldn't
it.
you have just gone out of the side door?
Thank you, Your Honor.
But Judge, if the garage door would have been working properly when I moved in,
You would have scored.
scored all day. Touchdown.
Now, Mr. Williams, I see that you have incurred $300,000.
This right here is what lawyers call comparative negligence gold. Did Mr. Williams have a safer exit? Yes. Did he forget the keypad code? Also, yes. Did he still sprint under a malfunctioning garage door like it was Friday Night Lights? Definitely. The judge is clearly weighing, is it still someone else's fault if you ignored the safe route? It's moments like this where personal injury cases get murky. It's not just about who got hurt, it's about who made the avoidable decision. What would you have done in that split second?
And then in response, Mr. Harris, you said, okay, I got it. What did you mean by that?
I just meant I understood him, Your Honor. I know what he's going through. I feel like I'm his friend. I try to bail him out and take care of him as much as I can. So when I said, okay, I got it, I mean, I understand what you're going through.
What did you think he meant?
I got it covered. That's what it says.
So you thought he was gonna pay for
I mean, yes.
This text thread might be the quiet bombshell of the case. I can't afford it. Okay, I got it. Simple words, wildly different interpretations. Mr. Williams thinks it means Mr. Harris agreed to cover the repair. Mr. Harris says I got it meant I understand. This is courtroom subtext 101, where one sentence becomes the turning point of a $425,000 claim. And in legal battles, miscommunication isn't just awkward, it's expensive. So let's hear from you. Was I got it a promise or just pity?
The reality is, though, that the law requires that everyone be responsible for what they contractually agreed to. In a personal injury case, there are three things that must be proven. You, Mr. Williams, have to prove that the Harrises were wrong and that their wrong caused your injuries. Clearly, you were injured because of that garage door. But the wrong is what is ticklish for me. Here, you had some choices about going under the door. Mrs. Harris, you made the point that he could have gone out the side door, and you could have. That would have been reasonable and safe. You all, on the other hand, you knew that this door was in bad shape. You also kind of knew he didn't have the money.
This is where the judge shows why he wears the robe. He doesn't go all in on either side. Instead, he slices the responsibility, 51% on the homeowners, 49% on Mr. Williams. Why? Because friendship doesn't override the lease. Mr. Williams should have used the side door, but the Harrises knew that garage was raggedy and did nothing. It's a legal and moral balancing act. The outcome? A chopped-down judgment, but still over $200,000. That's the cost of shared fault and broken friendships. So what did we learn from this case? Personal injury law doesn't care if you were best friends in high school or stood beside each other at the altar. The lease was legally binding, the garage door was dangerous, and the consequences were painful physically, emotionally, and financially. Mr. Williams walks away with over $200,000, but at what cost? This wasn't just a fall, it was the collapse of trust. If you found this case as jaw-dropping as we did, smash that like button, drop your verdict in the comments below, and hit subscribe for more deep dives into real courtroom drama that hits harder than a garage door. See you in the next case.